Hey guys, Gary with another legal tip here. As you know, over the last 4 or 5 weeks, we've been talking about interference with agency. We're going to talk about procuring calls and how that relates to the interference of agency. A lot of misunderstandings in the market about that. First of all, no one knows what procuring calls is, really. I mean, if you look at the definitions, they're all over the place. Realtors Association since the 1970s have tried to come up with a bright line test, come up with rules. Nothing really has seemed to match or get set. Even the Arkansas courts come up with craziness, saying it's not necessarily the squirrel who finds a nut, it's the squirrel who gathers a nut. I mean, we got to use squirrels now to try to do the definition of this thing. It's absolutely nuts. There's also this belief in our market that procuring calls is state law, that it's written into a statute. There is no statute about procuring calls. You're not going to find it in 4057. The real estate statute is not written to make sure you get paid. There's nothing in there about that. The best claim I think we'd have is maybe that it's case law, or that the Realtors Association has come up with procuring calls, but not everybody's a realtor. And I also think that the realtor's statement about what procuring calls is on a national level doesn't necessarily apply on the state level. Why do I say that? Well, South Carolina is quite different. I don't know if you've noticed that, but we have a lot of different laws and rules, and particularly in real estate. If you look at real estate, South Carolina is one of, I think, 7 states now that still require a real estate closing attorney to do the transaction. So we're different than 43 states. 43 states don't have that, only 7 do. So we're already different in how the real estate transaction works. The same thing is with agency. South Carolina is leading, yes, leading on buyer agency. Part of this whole Sitzer-Burnett case was about buyer agency. They wanted the touring agreement, the agreement that says how, when, where, and what you're going to do to get paid. South Carolina already had that. We already have buyer agency. And so if you think about some of these rules that they've come out nationally, they don't necessarily apply to South Carolina. One of the ways that the Realtors Association procuring calls I don't think necessarily applies is when they talk about you have to look at the totality of the events to see who the procuring calls is. I can agree with that. But when they say agency doesn't matter, that doesn't apply to South Carolina. And I'll tell you why it doesn't apply to South Carolina. Because in South Carolina, it is against the law. Yes, that is the correct term, against the law to provide client services without having a written agency agreement. If you do that, you are violating the law. If you provide client services without the agreement, such as advice, counsel, or advocacy, you are violating the law. I really don't know how you show somebody a house and get under a contract without having client agency. That's just beyond me, first of all. But let's suppose that you did that and you kept them as a customer. You have to have a signed transaction brokerage agreement as to how, when, where, and what you're going to do to get paid. So doing any of that is against the law. It is also against the law to interfere with somebody's agency. And the Real Estate Commission has been very clear. Interference is a requirement. You cannot do it. It's not like, well, do your best. It's you may not. You shall not interfere. And simply just saying, well, I didn't know, I didn't ask the questions, isn't good enough. You have to make the affirmative action. So when somebody comes with unclean hands, that's a doctrine in South Carolina. You can't come to court doing something wrong and expect to reap the benefits of it. When somebody comes to a court with unclean hands, they don't get the benefit. And in these cases of procuring cause, when somebody has broken the law by interfering with agency, when somebody has broken the law by providing client services without having an agency agreement, when somebody has broken the law and is trying to get paid without having a signed agency agreement, they don't get to reap the benefits and claim, well, I was procuring cause. If you think about this from how this would work, if you could essentially violate everybody's agency and become the procuring cause and get paid on every one of those, there's no point of having agency. If there's 10 real estate agents with signed 10 agency agreements, and I go to every one of those buyers and interfere with the agency and get all 10 buyers to go look at 10 houses with me and don't get documents signed as I'm supposed to, don't verify that they're working with another agent, and I get them to sign contracts and I close them, I'm the procuring cause. I'm the one who showed them the house. I'm the one who got the contract. Then what's the point of the agency? There's no point. There's no protection for anybody under the agency. So it makes absolutely zero sense for somebody to try to claim that I'm procuring cause, I get paid, even though I didn't follow state law. It's a violation. There's no ifs, ands, or buts about it. It is against the law to violate somebody's agency agreement. It's against the law to get paid without a signed agency agreement or a signed transaction brokerage agreement. It is against the law to provide client services without having a signed agency agreement. You violate the law, you don't get to be procuring cause. That's simple. All right. Hope that helps you. We'll be back again next week with another discussion on agency. Y'all take care.